Welcome back to Local 5 Live. You know, one of the challenges of divorce cases is when there are kids involved and how best to meet their needs in what is often a pretty sensitive and sometimes contentious situation.
Here to share some insight on legal custody and physical placement of kids in divorce situations, Adam Bernander, a partner and family law attorney with Herrling Law Firm. Good morning.
Good morning, you guys.
Okay, so I understand there's a difference between custody and placement in a divorce case. Can you explain that?
Yeah, there is. It's odd, but a lot of times when people the first time I have a conversation with someone, they'll refer to them interchangeably, but they are very different concepts. So legal custody refers to who has the right to be involved in the legal decision making for the children until they turn 18. So things like whether they will have non-emergency medical care, what religion they'll practice, how involved they'll be in that religion, what school they'll go to, things like that. And then physical placement is what you would imagine. It's where the child actually spends their time. Yeah.
Okay. Certainly best if parents can agree on custody and placement issues, but what happens if they don't?
There's a pretty set statutory procedure for that, and the first thing that parties would do is they attend mediation. So if they're unable to come to an agreement outside of court or the court process, they go to a court-ordered mediation, and then if that process doesn't work, the next step is the court appoints a guardian ad litem.
So we're looking at some of the things that are custody or placement factors when it comes to making a decision. Could you go over some of these?
There's a long list, and that list is not all inclusive.
Sure.
So there are things like, you know, as practical concerns, like people's work schedules. You know, if somebody works a swing shift, they might not be able to get the child to school, so they'll look at that. They'll look at the history of who's been a more involved parent, and they may look at if there's problems, like if there's alcohol abuse or things like that, they'll obviously consider that. So.
Are the wishes of the child taken into account as well? I'm sure it would maybe depend on age and maturity, or?
Yes, yeah. There's misconceptions that, you know, if a child is 12 or 16 or things like that, that matters, but it really, it's kind of a sliding scale. The older the child is, probably the more important their opinion is, and also how mature they are. So if they're asking to stay at one parent's house because they get to eat pizza there all the time, that's probably not going to be weighed that heavily.
Sure.
But if that's the place where they can focus on work or homework and things like that, and they have a more stable environment, that opinion is going to matter more.
Okay. What are some reasonable expectations for parents who are entering a court case that involves contested claims of custody or placement?
Well, like I said, the process is long, so they should expect a long process. The first process is they'll go to mediation, like I said, then a guardian ad litem will investigate the case. They usually have at least 90 days to do that investigation, and if they're still unable to come to an agreement, then it's a full-blown trial like you see on TV.
Yeah.
Where parties will call witnesses, they put forth their evidence, and then the judge will make the decision.
And how can Herrling Clark help in these situations?
Well, really, I think we were talking about expectations. Managing expectations is an important thing, and also going through all those factors and helping people try to come to agreements, because that really is best for everybody if there's an agreement, especially when you're talking about issues with children.
Absolutely, a partner that you want at the table with you. Herrling Clark has offices in Appleton, Green Bay, Oshkosh, and Wapaka.
You can reach them at 920-739-7366. Online, herlingclark.com.